Hello friends, I'm Shantanu, your coach, and now we are going to cover another chapter, a small chapter, Right to Information Act. And from this, there can be a 5 marks question that can be asked in the exams. So first we will see the introduction of this act. The name of this act is Right to Information Act 2005. This act mainly focuses on the accountability in the public authority to disclose the information to the general public. There was a famous case law that was RP Limited versus Indian Express newspaper, and in this case law the Supreme Court held that Article 21 of the Constitution confers all the person a right to know, which include a right to receive information as well. तो यहाँ पर आपको आर्टिकल 21 जो कॉन्स्टिट्यूशन का है उसका मेंशन करना है. And right to receive information is basically linked to the right to freedom of speech and expression which is provided under the Constitution. Further, Article 19(1)(a) of our Constitution guarantees all citizens freedom of speech and expression. This article you also have to quote in the exam. And the prerequisite for enjoying this right is the knowledge and information. So this is the basis on which this act was formed. So in nutshell, you can say that there are 2 articles of the Constitution. Article 21, which says all the person have right to know, and which includes a right to receive information. And Article 19(1)(a) says that there is a freedom of speech to all the citizens. So on the basis of these 2 articles, this act, that is Right to Information Act 2005, is based. Now there are some important definitions which are given under this act, so we will see all the definition one by one. First, it says that public authority, that is given under section 2H. So public authority here means an authority or body or institution of the government established or constituted by under the Constitution, if it is formed under the Constitution, or if it is made under any other law made by the Parliament, or under any law made by the state legislature, or it may have been formed by notification issued or order made by the appropriate government. So all these authorities, bodies or institutions which are established or constituted under these will be treated as public authority as per section 2H. Second definition is given about the record, which is given under section 2(1). A record includes any document, manuscript and file, any microfilm, microtech and facsimile copy of a document, and a reproduction of image or images embodied in such microfilm and any other material produced by a computer or any other device will be treated as a record. So basically this definition is an inclusive definition. So specifically it is saying that these will be treated as records. Again, it defines the term information. Information means any material in any form. Any material in any form, including so many things you have to mention. You can mention in the exam at least 2 to 5 things if you can remember. So information means any material in any form. This is the keyword you have to write, including record, document, memo, email, opinion, advice, press release, circular, order, logbooks, contracts, reports, paper, samples, models, data material held in any electronic form will be treated as information. Now the most important section is 2(1), that is the right to information. Here right to information is defined, and it means the right to information accessible under this act, which is held by or under the control of public authority. So 2 things are very clear about the right to information. First, whatever information which is accessible under this act will be treated as will be covered under right to information. And second, it talks about that information which is held by or under the control of any public authority. So here focus will be records with the public authority. Private enterprises are excluded here. And it includes right to taking notes. So here inclusive definition starts that it includes right to taking notes, extract, certified copies of the document or record, inspection of work document record, taking certified sample of the material, obtaining information in the form of disk, floppies, tapes, video cassettes in any other electronic mode through printouts, where such information is stored in a computer and in any other device. Now, this act further talks about the obligations of public authority who is maintaining the records. So, every public authority under this act has been entrusted with the duty to maintain the record and publish the manuals, rules, regulation, instruction, etc. It is in possession and prescribed under the act. So, यहाँ पर clearly बोला गया है सभी public authority को कि उनकी ये ड्यूटी है कि उनको रिकॉर्ड मेंटेन करने पड़ेंगे और नॉट ओनली रिकॉर्ड मेंटेन करने बट दे विल हैव टू पब्लिश द मैनुअल्स, रूल्स एंड रेगुलेशंस आल्सो. As per section 4 of this act, every public authority has to publish within 120 days of the enactment of this act. तो जैसे ही ये act effective हो जाता है उसके 120 days के अंदर अंदर every public authority will have to publish following things. First, particulars of the organization, functions and duties of the organization. Second, power and duties of its officers and employees. Then, procedure followed in its decision-making process, including channel of supervision and accountability. Then, the norms set by it for discharge of its functions. And rule, regulation, instruction, manual and records used by employees for discharging its functions. Then there will be statement of categories of document held by it or under its control. Apart from this, there will be particulars of any agreement that exists for consultation or representation for formulation of policy or implementation thereof. Then directory of its officers and employees. Then it talks about the monthly remuneration received by each of its officer and employee, including the system of compensation as provided in its regulation. Then the budget allocated to each of its agency, indicating the particulars of all plans, proposed expenditure or reports or disbursement made. The manner of execution of subsidy programs, including the amount allocated and details of beneficiaries of such programs. Particular of receipt of concessions, permits or authorization granted by it. Details about the information available to or held by it reduced in electronic form. So, अगर electronic form में कोई information है तो उसकी जानकारी भी देना है. The particulars of facilities available to citizens for obtaining the information, including the working hour of a library or reading room if maintained for such public use. The name, designation and other particulars of public information officer. This is very important officer created under this act. So यहाँ पर नाम, उसका designation और उसके particulars देने पड़ेंगे public information officer के. And apart from this, any such other information as may be prescribed should be updated and should be published every year. Then there is a very important position, that is the designation of public information officer. We will call it a PIO. Every public authority has to do the following. First, designate in all its administrative unit or offices the central and state public information officers. So हर एक unit या offices में उसको एक PIO को designate करना पड़ेगा, किसी person को as a PIO, to provide information to person who have made a request for that information. तो कोई भी person है जिसको कोई information चाहिए वो सीधे जा सकता है PIO के पास. And designate at each subdivisional level or sub-district level central assistant or central assistant public information officer. तो इसके अलावा सब डिविजनल लेवल पे उसको और क्रिएट करना पड़ेगा, that is सब डिस्ट्रिक्ट लेवल central assistant or state assistant public information officer to receive the application for information or appeals for forwarding the same to the central or state public information officers. Now this act also specifies how to obtain the information under this act. What is the procedure? So first, PIO shall deal with the request from persons seeking the information. So any person if want any information, he should approach to PIO. If the information is requested what is held by another public authority, अगर वो information किसी और public authority के पास है, तो ऐसे केस में PIO shall transfer within 5 days the request to that other public authority and inform the applicant immediately. PIO on receipt of request shall expeditiously as possible, जितना जल्दी हो सके उसको वो information provide करनी है, and at the max within 30 days of receipt of request he should provide the information which was requested on the payment of such fees as may be provided. And where the information requested for the concern of life or liberty of a person, ये बहुत ही important है, अगर किसी की life या liberty of a person से वो information related है, in that case the same should be provided within 48 hours of the request. This act further says that if the PIO fails to give the decision on the request within a period specified, he shall be deemed to have refused the request. तो अगर उसने वो डिसीजन है यानी जो भी इंफॉर्मेशन मांगी वो नहीं दी, तो ऐसा मान लिया जाएगा कि PIO ने उसको रिफ्यूज कर दिया है इंफॉर्मेशन देने से. So where request has been rejected, the PIO shall communicate the following to the requester. First, he will have to give the details of reason for such a rejection, why it has been rejected. Second, the period within which an appeal against such rejection may be preferred. तो उसको ये भी बताना पड़ेगा कि आप इस रिजेक्शन के अगेंस्ट अपील फाइल कर सकते हैं और कितने दिन में फाइल कर सकते हैं. एंड द पर्टिकुलर्स ऑफ अपीलेट अथॉरिटी, तो आप ये अपील जो है इस रिजेक्शन के अगेंस्ट ये कहां पर किस अथॉरिटी के पास फाइल कर सकते हैं. दिस ऑल्सो शुड बी गिवन टू द एप्लीकेंट. Now there are certain exemptions from disclosure. तो हर एक इंफॉर्मेशन तो इंफॉर्मेशन एक्ट में शेयर नहीं हो सकती. There are certain secret information जो important है for the safety of the country, confidential है, उस तरह की इंफॉर्मेशन एक्ट में नहीं दी जा सकती, उनको exempt रखा है इस एक्ट से. So where disclosure prejudicially affect the sovereignty or integrity of India, ये words आपको याद रखने हैं. If any disclosure of information is affecting the sovereignty and integrity of India, then such information will not be provided under this act. For example, information which has been expressly forbidden by any court or tribunal or disclosure of which may constitute contempt of court should not be provided under this act. Second, where disclosure would cause a breach of privilege of parliament or the state legislature, this information should also be not provided. Information including commercial confidence and the trade secret or intellectual property, these details should also not be provided under this act. Again, the information received in confidence from a foreign government, तो foreign government से कुछ information मिली है, secret information, that should also not be provided. Information, the disclosure of which endanger the life or physical safety of any person or identifies the confidential source of information or assistance, then such information will also be not provided. Again, the information that would impede the process of investigation or apprehension or prosecution of offender. तो अगर ऐसा कोई investigation जो अभी चल रहा है उसको वो hurt कर सकता है, उसको वो affect कर सकता है, ऐसी information अगर दी तो उस केस में भी वो information नहीं दी जाएगी. Then the cabinet papers, including the record of the deliberation of the council of ministers, secretaries and other officers, and the decision taken there, it will not be given under this act. Now let's see three sections, section 8, 9 and 10. Section 8 is related to personal information. So personal information which would cause invasion of the privacy of a person will not be disclosed unless larger public interest justifies it. तो personal nature की information नहीं डिस्क्लोज होगी इस एक्ट में unless there is interest, general public interest involved. तो अगर public interest में उसको disclose करना पड़े तो वो आप इस एक्ट में कर सकते हैं, otherwise personal nature की information will not be disclosed. Second, section 9 talks about the infringement of copyright information. So section 9 empowers the public information officer, that is PIO, to reject a request for information where providing such information may infringe a copyright of any person. So अगर ये information देने से copyright infringe होता है किसी person का, तो that information will not be provided under this act. Then section 10 deals with the part of the record. अगर आप पूरी नहीं information दे सकते हैं तो क्या partly information दे सकते हैं? तो section 10 says that only that part of the record which does not contain any information which is exempt from disclosure. तो ऐसी कोई information नहीं है जो exempt है disclosure से, तो ऐसा कोई part है which can be reasonably be severed, और उसको अलग से सीवर किया जा सकता है, यानी उसको अलग से निकाला जा सकता है from the other part which is exempted from the disclosure, that may be provided. This is known as partial disclosure. For example, this is the full information, और ये जो A part की information है, this is exempt from disclosure under this act. तो इस part की information को आप disclose नहीं कर सकते. But B part है इस information का, that is not exempt from disclosure and it can be severed from the part A. उसको अलग किया जा सकता है part A से. तो ऐसे केस में ये जो part information है, that should be provided to the applicant, and this is known as partial disclosure. Now let's see who is excluded from this act. As we have seen that all the public authorities will have to provide the information, but there are certain authorities which are excluded, like Central Intelligence Security Agency specified in the second schedule of this act, like IB, Raw Directorate of Revenue Intelligence, etc. So these are the authorities which are excluded from the purview of this act, and also the agencies which are specified by the state government through the notification will also be excluded from the purview of this act. However, you have to remember that, however, the exclusion is not absolute. यानी ये blind exclusion नहीं है. The organization have an obligation to provide the information pertaining to all allegation of corruption and human right violation. तो अगर कोई corruption का matter है या human right violation है, then the authorities will have to disclose the information. Further, the information relating to allegation of human rights violation shall be given only with the approval of the Central Information Commission within 45 days from the date of receipt of the request. Now let's see the Information Commission. So Information Commission will be formed under this act. There will be two Information Commission. First, Central Information Commission, and then second, State Information Commission. So first let's see the Central Information Commission. This commission will be constituted by the central government, and this will consist of one chief Central Information Commissioner, and there will be other Central Informational Commissioner not exceeding 10. So the Chief Commissioner and the Informational Commissioner shall be the person of eminence in public life, wide knowledge, experience in law, science, technology, social service, management, journalism, mass media or administration and governance. So they should have experience or knowledge of these. And these commissioners shall not, ये इसके ऊपर क्वेश्चन आ सकता है, these commissioners shall not be a member of parliament or member of state legislature of any state or union territory, and he shall not hold any other office of profit or which is connected with any political party or carrying on any business or pursuing any profession. The commissioner shall be appointed for a term of 5 years or till he attains the age of 65 years, whichever is earlier. Another important point is that the Chief Central Informational Commissioner shall not be eligible for the reappointment. Now similarly, there will be State Information Commission that will be constituted by the state government, and it will consist of one state Chief Information Commissioner and not more than 10 State Information Commissioners. And the qualification for these commissioners will be same as we have seen in the Central Commissioner. Now let's see the powers and duties of these information commissions. The first duty of these Central Information Commission and State Information Commission is duty to receive the complaint from any person who has not been submitted any information which he has requested, because PIO has not been appointed. There may be chances that there is no PIO in the public authority, so the commission will have to see the complaint regarding that, or who has been refused the information. That means there was a PIO but he has refused the information, then the complaint can be filed with the commission, or who has received no response from the PIO within the time, or the fees charged by the PIO was unreasonable, or the information which was provided was incomplete, or it was false or misleading. In all such cases, complaint can be filed with the information commissions. The commission, when it feels that the inquiry should be initiated in such matter, then the commission will start the inquiry, and for this purpose the commission will have the same power as which is vested in the civil code. And while investigating any matter, this commission may examine any record. Remember here, any record this commission may examine which is within the control of any public authority, and no such record may be withheld from it on any ground. तो कोई भी रिकॉर्ड इसको, जो भी ये डिमांड करता है कमीशन, इसको वो रिकॉर्ड देना ही पड़ेगा पब्लिक अथॉरिटी को. There is no reason for not giving the record to the commission. Now let's see the provisions related to appeals. So if a person is not getting the desired information within the time, then he can file an appeal. So there are two levels of appeal, first level appeal and then second appeal. So first appeal shall be filed to the officer who is senior in rank to the PIO in the concerned public authority. तो जिस पब्लिक अथॉरिटी से वो इन्फॉर्मेशन चाहता है, उसी में जो सीनियर रैंक का ऑफिसर है, हु इज अबोव द PIO, the appeal can be filed with that officer within 30 days from the prescribed time limit. Again, the first appeal shall be disposed. So whenever you file a first appeal, the concerned officer will dispose of this appeal within 30 days from the receipt of such application or appeal, or within such extended period not exceeding a total of 45 days from the date of filing the appeal for reason to be recorded. तो maximum जो time है, normal time to dispose of the appeal is 30 days, but it can be extended to 45 days, but the officer will have to record the reason for the delay. Then there is another provision of second appeal. So second appeal shall be filed to Central Information Commission or the State Information Commission, as the case may be, within 90 days from the date on which decision was given or should have been made by the first appellate authority. तो अगर first appellate authority ने कोई decision दिया है and he is not satisfied, the applicant is not satisfied, he can file an second appeal to either Central or State Information Commission within 90 days of such decision. Or if he has not, the first appellate authority has not given any decision, then whatever was the maximum time period, as we have seen, the maximum time period was 45 days, then the end of 45 days he can file a second appeal to Central Information Commission or State Information Commission within 90 days from the end of 45 days. And one thing you always have to remember, that whatever time limit is fixed for filing the appeal, if the authority, the appellate authority may accept the belated appeal also if it is satisfied that there was a sufficient cause which prevented the applicant to file the appeal within the designated time. Now let's see section 20, which talks about the penalties. Every PIO will be liable for a fine of rupees 250 per day up to a maximum of 25,000 for following things: not accepting the application, he may be penalized, or delaying the information release without any reasonable cause is delaying the information, then also he can be penalized, or malafidely denying the information, or knowingly giving incomplete, incorrect or misleading information, or destroying the information that has been requested, or obstructing the furnishing of information in any manner. In all such cases, the PIO may be penalized 250 rupees per day up to a maximum of 25,000.